Presidential Memorandum, Preventing Abuses of the Legal System and the Federal Court, March 22, 2025. Purpose of the Memorandum. The memorandum, addressed to the Attorney General and the Secretary of Homeland Security, lays out a policy directive to combat unethical behavior by lawyers and law firms, especially in litigation involving the federal government. It emphasizes accountability for legal misconduct, particularly when such actions threaten national security, public safety, homeland security, or election integrity. Key concerns raised. 1. Unethical legal practices. The memo claims lawyers are increasingly engaging in unethical or illegal practices, undermining the integrity of the legal system. Cites Mark Elias and the 2016 election dossier as an example of alleged misconduct aimed at manipulating a presidential election. Suggests that lawyers sometimes intentionally conceal client roles in politically charged or deceptive legal maneuvers. Second, immigration system abuse. Highlights claims of widespread fraud and meritless asylum filings in the immigration system. Accuses immigration attorneys and pro bono firms of coaching clients to lie or omit facts to bypass immigration laws. States these practices burden the government and contribute to illegal immigration, public safety threats, and strain on taxpayer resources. References tragic incidents, e.g., Locke and Riley, Jocelyn Nungaray, Rachel Morin, as alleged consequences of lax enforcement. Legal standards cited. Federal Rule of Civil Procedure, FRCP. 11. Prohibits improper legal filings, e.g., those meant to harass or delay. Requires legal arguments to be based on existing law or a reasonable basis for changing the law. Sanctions are available when attorneys violate these requirements. ABA Model Rule 3.1 bars attorneys from bringing frivolous claims without a factual or legal basis. New directives. 1. Pursuing sanctions. The Attorney General, AG, is ordered to seek sanctions against attorneys and firms filing frivolous, unreasonable, or vexatious litigation against the federal government or its agencies. 2nd. Enforcement of attorney conduct regulations. The Attorney General and Secretary of Homeland Security must prioritize enforcement of attorney discipline regulations, particularly 8 CFR Sections 292.1, 1000, and 3.101, and 1292.19, governing attorney conduct in immigration proceedings. 3rd, referral for disciplinary action. The AG must refer attorneys for discipline if their actions appear to violate ethics rules, especially in areas involving national security, public safety, homeland security, election integrity. The AG is also to consider whether law firm partners should be held accountable for misconduct by junior attorneys under their supervision. 4. Further executive actions. In cases warranting sanctions or discipline, the AG should recommend further actions to the President, such as re-evaluating security clearances, terminating federal contracts with offending attorneys or firms. 5th, review of past misconduct. The AG must review litigation from the past 8 years involving the federal government to identify any unethical conduct. If misconduct is found, the AG should recommend additional steps, e.g., contract termination, clearance reassessment. Vision and follow-up. The memo concludes by reiterating that lawyers have a duty to uphold the rule of law. The Attorney General and White House counsel must report periodically on progress and improvements by law firms in meeting these expectations. Tone and implications. The memo carries a highly critical tone towards certain lawyers, especially those challenging the federal government or involved in immigration and election-related cases. It suggests a more aggressive use of sanctions and disciplinary referrals, and possibly political consequences, e.g., clearance review or contract loss, for those found in violation. It may signal a broader effort to deter legal challenges to federal policies, particularly in politically sensitive areas. Subscribe for more!